Companies Act 2016. Section 261 Auditor's Statement. A company shall lodge with a registrar with a statement relating to the financial statements of the company required to be circulated to its members, which signed by auditor of the company that states: first, to keep proper accounting records and other books. Second, financial statement have been audited in accordance with this act. Third, auditor's report on the financial statement was made subjected to any qualification or opinion under applicable auditing standard, and lastly, the ability of the company to meet its liability at the date financial statement made up when the liabilities fall due. The company and every officer who contravene this section commits an offense and shall be liable to a fine of less than Rm 20,000, and if the offense continue, the additional fine of less than Rm 1,000 for each days after conviction of the offense continue.
Section 263 Company Auditor's Qualification. Number 1 is any person who wants to become a company auditor can apply to the Minister of Finance. Then number 2, a person who are qualified is that person having a good character and competent to perform the duties of an auditor may be approved as a company auditor by the minister if he satisfied it upon payment of the prescribed fee. Next is number 3, for any approval granted by the minister under 2 is a subject conditions or limitations as he thinks it qualify and may be revoked by him at any time by the service of a revocation notice on the approved person. Number 4. Every approval including a renewal of approval of a company auditor is to be in force for period of 2 years after the date of issue unless revoked by the minister. Number 5. The minister may delegate all or any of his powers to any person, or body of person whom responsible for the registration or control of accountants in Malaysia under this section. Number 6. If he is aggrieved with any decision of the minister or with the decision of any person or body of persons to whom such minister has delegated all or any of his power, he may appeal to the court under this section. Lastly, number 7. Persons as defined by under the Accountants Act 1967, Act 94, means chartered accountant under this section. Section 264 Company Auditors, Disqualification. Number 1. A person must not: firstly, give authorized to be appointed as an auditor for any company. Then, act as an auditor for any company, or, then, prepare for or on behalf of the company any report required by the Act to be prepared by an approved company auditor, if first, he is not an approved company auditor. Second, he is indebted to the company or any corporation that is deemed to be related to the company by virtue of Section 7, which is an amount more than Rm 25,000. Third, he is A, or his spouse is, an officer of the company. B, a partner, employer, or employee of an officer in the company. C, a partner or employee of an officer in the company. D, a shareholder or his spouse is a shareholder of a corporation that the employee is an officer of the company. Then, he is responsible for, or if he is the partner, employer or employee of a person responsible for the bookkeeping of the registered members or debenture holders of the company. Besides, he is undischarged bankrupt within or outside Malaysia except with leave of court. Lastly, he was convicted with any offence such as fraud or dishonesty that is punishable with imprisonment of 3 months or more. Number 2. A person is considered to be an officer of the company if he has been an officer or promoter of the company at any time within the preceding period of 12 months unless minister directs otherwise. Number 3. A person cannot be considered as an officer just because he have been appointed as auditor of the company. Number 4. A firm of auditors must not give consent or act as auditors for any company by preparing for or on behalf of the company any report required by the Act. J is to be prepared by an approved company auditor, unless: firstly, all partners of the firm resident in Malaysia are approved company auditors where: Number 1, the firm is not registered as firm under any law for the time being, and Number 2, full names and addresses of all partners of the firm has been lodged with the registrar. Number 5. The company must not appoint a person or firm as an auditor of the company, unless: first, that person have given their consent to act as an auditor of the company. Then, if in a firm, at least there is one partner in the firm have given their consent in writing. Number 6. The appointment of a firm in the name of the firm as auditors of a company shall take effect as an appointment as auditors of the company of the persons who are partners of that firm at the firm of the appointment. Number 5. The company must not appoint a person or firm as an auditor of the company, unless: first, that person have given their consent to act as an auditor of the company. Then, if in a firm, at least there is one partner in the firm have given their consent in writing. Number 6. The appointment of a firm in the name of the firm as auditors of a company shall take effect as an appointment as auditors of the company of the persons who are partners of that firm at the firm of the appointment.
For Section 267, that is appointment of auditor in private company, there is two ways auditor to be appointed: by the board of director and the members of the company. The board of director should appoint auditor for a new company and fill in the job vacancy. Members of company. The member of company appoint the auditor when the next following year after first financial statement period to appoint, and board of director appoint based on the board of director method should appoint the auditor. An auditor shall be appointed by both board of director and members of the company in accordance of the law. The period for appointing an auditor are before financial statement is lodged and after it is lodged. If the company violate this section, it is considered as breach the law. Next is Section 271, appointment of auditors in public company. The board of director should appoint an auditor at any time before the first annual grand meeting of the company and fill in the job vacancy. Auditor that has been appointed should fill in the position until the final decision of the first annual grand meeting and the next annual grand meeting for the appointment. Member of company. An auditor shall be appointed by the members of the company at annual general meeting and when the company has failed to appoint at the annual general meeting. Also when the board of director failed to appoint at the annual general meeting. An auditor is to be appointed in accordance by the board of director or the member of the company. Company who violate this section is considered as violating the law as well. For Section 276, resolution to remove an auditor from company. Auditor can be removed from the company at any time by an ordinary resolution and in accordance to Section 277, that is special notice required for resolution to remove an auditor from the company. The right to compensate for any damages to the auditor cannot be denied by the company after the resolution in respect of his termination. An auditor cannot be removed from the company until his term is expired except by resolution under this section. For Section 277, special notice are required to remove auditor from office. To remove an auditor, a special notice are required from the office at the general meeting of a company. After receiving the special notice, the company then shall immediately send the copy of the special notice to the registrar and the auditor that are to be removed. The auditor are given by within 7 days of the receipt of special notice to make a representation in writing and may request for a meeting to defend himself. The copy of the representation should be given to every member whom the notice of the meeting is sent. If the copy that is not sent as required, the auditor can require the representation to be read out at the meeting. But, if the court the auditor is using this section for unnecessary publicity or defamatory or some other grounds that the court thinks reasonable, the copy of representation will not be circulated or not be read at the meeting.
First, every auditor of a company must report to the members of the financial statements and on the company's accounting and also other records relating to those financial statements. If it is the holding company for which consolidated financial statements are prepared, must report to the members on the consolidated financial statements, and the reports are for public company, laid before the company at its annual grand meeting. Then for private company it have to be circulated to its members, or laid before the company at a meeting of members. Then, an auditor must know whether the financial statements by a holding company which are consolidated financial statements are prepared are properly drawn up on his opinion. To give a true and fair view of the matters required by Section 248 for financial statement. To give a true and fair view of the company's affair in accordance with this Act. After that, financial statements are required to be prepared for lodged. As such, the financial statements must be made in accordance with the applicable approved accounting standards, whether the financial statements have not been drawn up in accordance with a particular applicable approved accounting standard on his opinion. If it is drawn up in accordance with the approved accounting standard, have given a true and fair view of the matters required under Section 248 to be dealt with in the financial statements. Then if it is drawn up, it must give a true and fair view of these matters for holding the opinion in his reasons. After that, if the directors have give the particulars of the quantified financial effect under Section 244 concerning the particulars in his opinion. And then, if both applies, the particulars of the quantified financial effect on the financial statements on the failure to drawn up the financial statements. Next, the name of any subsidiaries have not acted as an auditor of the company, in the case of consolidated financial statements. After that, any deficiency or any irregular matter that not set out in the financial statements without regard of a true and fair view would not be obtained. But, if unsatisfied with any matter that has stated in the above situation, he must state his reasons for not being so. An auditor of a company must have a duty to give opinion for each of the following matters, which are: whether it has obtained all the information and explanation required, or whether proper accounting and other records including registers been kept by the company as required by the Act, or whether the returns received from branch offices of company are acceptable, or whether the procedures and methods used were appropriate to the circumstances of the consolidation. And the auditor shall state in his report the particulars of any misstatement, failure or shortcomings related of any matters in this subsection, Section 281. Resignation of an auditor. In this first subsection, it tells us that when an auditor resigns from his office, a copy of the notice to the registrar within 7 days from the receiving of a notice resignation will be sent by the company to the auditor. And then, under subsection 1, the term of notice of an auditor will come to an end after 21 days when the notice of resignation had been submitted or from the date specifies in the notice. The first subsection, when an auditor resign, the company is to send a copy of the notice to the registrar within 7 days from receiving the notice. The second subsection, the company and every officer who go against this section is considered as committing an offense. The first subsection, the notice of resignation is to be attached with the statement of the circumstances concerning the auditor's resignation. The second subsection, referring to Section 281, the auditor may present the notice of resignation with a signed requisition that demand the directors of the company to hold a general meeting where the auditor's circumstances concerning his resignation is to be received and heard. The third subsection, the auditor may request the company to circulate a statement in writing, that does not exceed a reasonable length, concerning the circumstances of the auditor's resignation to its members. Before the meeting held, an auditor's requisition, or before any general meeting at which the auditor's term of office is expired or the vacancy caused by the auditor's resignation is filled in. The fourth subsection, the company shall declare the statement referred in subsection 3 has been made in any notice of the meeting given to the members of the company. Send a copy of the statement to the members of the company that the notice of meeting was sent to. The fifth one, the directors shall hold a general meeting within 28 days from the receiving date of the notice of requisition made under subsection 2. The sixth subsection, an auditor must read out the statement at the meeting if the copy of the statement based in subsection 4 is not sent out as required due to the default of the company. The seventh subsection, the copy of the statement will not need to be sent and read out loud in the meeting if the court is satisfied that the auditor is using this section for unnecessary publicity or if the matter is scandalous. The eighth subsection, the company's cost on such as an application to be paid in whole or in part by the auditor, may be ordered by the court, in spite of the auditor not being in a party to the application. Next subsection, notwithstanding his resignation, the auditor who has decided to resign has the rights consulting by section 285 in any of the relation to any of the general meeting of the company as have mentioned in subsection 3a or b. The 10th subsection, any of the reference in section 285 that matters as regards to the auditor as an auditor shall be analyzed as references to the matters concerning the auditor as a former auditor. The last subsection, if all the reasonable steps to ensure and secure that a meeting is assembled under subsection 5, failed to be taken by every directors, they have commit an offense. Section 274 Fixing of Auditor's Remuneration. The remuneration of an auditor was appointed by first member of the company, which is it will be decided by the ordinary resolution that require majority or half of votes to be passed, or the member will decide on any other way. Second, the board of director of the company. Third, the registrar, the board or the company. Lastly, the remuneration will involve amount of payment and expenses relating to the auditor's service otherwise than cash. After that, an auditor of the company has the right to access accounting and other records including registers of the company and is entitled to require information and the explanation as desired from any officer of the company, any auditor of a related company for the purpose of auditing. Then, an auditor of holding company that require consolidated financial statements has a right to access accounting and other records including registers of any subsidiaries if necessary any time. Is entitled to require information and explanation related with any officer or auditor of any subsidiaries included in the consolidated financial statement. Next, auditor's report must be attached with the financial statements. If any member requires, it must be read before the company in general meeting and shall be open for inspection by any member at any reasonable time. Lastly, an auditor of a company is entitled to attend any general meeting of the company and to receive all notices, and other communications relating to any general meeting. He is entitled to be heard at any general meeting when he attends any part of the business of the meeting on matters which concerns his power as an auditor.